All right, I think
Yeah.
we'll, we'll start the session now. Good morning, everyone. On behalf of Jindal Global Law School, I am pleased to welcome Advocate Vindhya, joint partner at Lakshmikumaran and Sridharan, a leading law firm in India. Vindhya works in the firm's technology division and brings with her a Master's in Laws or BCL from the University of Oxford with a focus on intellectual property or IP. With over 7 years of work experience, Vindhya has garnered expertise in IP opposition and litigation. She works with a wide range of clients and makes regular appearances before the Trademarks Office, Patent Office, Plant Variety Protection Registry, High Courts, and the Supreme Court of India. Apart from key IP services, Vindhya works on regulatory audits, provides advice, and helps clients with litigation under the Biological Diversity Act 2002. On an interesting note, Vindhya and I are both alumni of the University of Delhi batch of 2012. As a housekeeping issue, please may I request the audience to keep their speaker phones on mute during the presentations and the video mode turned off. We encourage you to ask questions by placing them in the chat box. While we might not be able to take all the questions, some of these questions could be addressed during the Q&A. Now, today's discussion focuses on the intersection between patent law and biodiversity. The intersection stems from Section 6 of the Biological Diversity Act 2002. I will simply call it the BDA. This provision prohibits a person from applying for intellectual property rights based on any research or information from a biological resource that is obtained from India unless approval from the National Biodiversity Authority or the NBA has been received. Now, this term biological resource is fairly broad and is defined under Section 2C of the Act as an inclusionary term. Biological resources under the Act include plants, animals, microorganisms, their parts, genetic material, and byproducts. But it does not include, interestingly, human genetic material. Now, the National Biodiversity Authority, coming to what it is an autonomous body regulating the access of India's biological resources. It has been empowered under Section 6, subsection 2 of the Act to impose a benefit sharing fee or a royalty for any research or information from a biological resource obtained from India. This includes sharing any financial benefits from the commercial utilization of these IP rights that have been provided on the basis of the patent being granted on India's biological resources. Now, a pertinent observation is the element of the internationally recognized aspect of access benefit sharing regime or ABS under Section 6. Now, the ABS concept has gained limelight through internationally celebrated cases such as South Africa's Hudia Case. Now, in the Hudia case, the indigenous San people of the Kalahari Desert were holders of traditional knowledge on the Hudia gordonii, or simply Hudia, a plant which was consumed by them to suppress their hunger. As a friendly and hospitable group, the San people shared their knowledge with a Dutch anthropologist who published it in his book way back in the early 1900s. Now, what the indigenous people did not realize was the value of their knowledge. Years later, the South African Council for Scientific and Industrial Research, that's CSIR, read the book and began to make further investigations about this plant. They identified a specific molecule that played an important role in suppressing hunger and were granted a patent. The patent was licensed to a pharma company. The idea was to commercialize the active ingredient from the plant in the form of an anti-obesity drug. Now, what seemed unfair and made headlines was that the San people were not recognized nor given their due for the knowledge that formed the basis of this invention. Now, the San people were a marginalized group, while the drug company sought to generate a profit from the commercialization of the drug. An access to benefit sharing agreement was subsequently entered between the pharma company and the San people, who were given a royalty from the commercialization of the drug. Now, globally, this access to benefit sharing regime is envisaged in the Convention on Biological Diversity 1992, or the CBD, and its supplementary agreement, the Nagoya Protocol. Now, the idea was for sovereign nations to protect and monitor the use of their biodiversity and traditional knowledge for research and subsequent patent grants. Conversely, any benefits obtained from these resources is equitably shared with the provider of the resource or traditional knowledge. That could be an indigenous group or a sovereign nation. Now, India has a form of the ABS under sections 3, 4, and 6 of the BDA. Now, under section 3, for example, there are broadly two categories of persons who are required to take permission from the National Biodiversity Authority for obtaining a biological resource and associated traditional knowledge from India for research or commercial utilization. Now, the first category is natural persons who are foreign nationals or residents. The second category is of artificial persons, but limited only to companies who are either foreign companies or Indian companies with a non-resident shareholding or management. Now, both these categories need permission from the NBA before obtaining a biological resource or associated traditional knowledge occurring in India. Now, conversely, under Section 4 of the BDA, an Indian citizen, resident, or company is mandated to obtain permission from the NBA before transferring any research related to an Indian biological resource to foreign citizens, residents, or companies. However, there is an exception to Section 4, whereby permission is not required for the transfer of biological resources between Indian and foreign institutions for collaborative research projects. Now, given this background on the interrelation between patents and biodiversity, the first observation is on the ambit of Section 6. It's a fairly wide ambit. So, for example, out of 40 resources of existing literature relied on by a foreign inventor in a patent specification, let's say one source is a study, say, on the neem tree found in India. Now, does the foreign applicant need permission from the NBA since the research is obtained and the emphasis is on the word obtained from India? Now, the answer from the language of Section 6 seems to be yes. You've used neem tree, even if it's one source out of those 40 sources, you have to go to the NBA and you have to take permission from them. Now, the question then is, what happens if the resource is freely available, like the gum Arabic tree or in vernacular, the kiko tree? Does permission still need to be taken from the NBA? The answer again from the language of Section 6 is yes. Now, but hold on, but I just need a small quantity, says the researcher. Uh, the researcher needs a part of the kiko tree in a very minute quantity. Does permission still need to be taken? The answer is in affirmative. So regardless of the nature, price, or quantity of the biological resource, Section 6 requires approval from the NBA prior to filing a patent application. If, of course, the invention is based on a biological resource from India. Now, this could be a cumbersome process if the neem or kiko tree is ancillary to the main research or does not form a significant portion of the research. It could be a disincentive if permission is required for every biological resource from India. Rather, the foreign researcher may decide to focus on a study in other jurisdictions with more favorable biodiversity laws. Such a stringent obligation may even give rise to omissions in the patent applications. Now, on the flip side, the argument is the stringency is justified for preserving Indian biodiversity. Now, what seems to be in abundance today and of no value could diminish in size due to anthropogenic activities and be a scarce resource. A sovereign nation rich in biodiversity like India may find the need to regulate the use of its biological resources for sustainable development. The second observation, and a pertinent observation, is does the foreign inventor require permission for a previous research on an Indian biological resource that forms the basis of a current patent application when no such permission had been taken for the previous research? So, for example, the foreign applicant had conducted research on the Indian neem tree before the BDA came into force and has used the previous research in the current invention. Now, does this mean the foreign applicant requires permission for the previous and the current research conducted on the neem tree? The question delves into the retrospective effect of the BDA and requires clarification. Although in September 2018, the Ministry of Environment, Forest and Climate Change issued an office memorandum directing all cases where permission from the NBA was required under sections 3, 4, and 6 in the past, and that permission had not been taken to rectify any defaults and comply with the provisions. But wait, hold on. All the office memorandum said was if you did not take permission when you were required to take permission in the past, you could do so now. But there was no cutoff mark or there was no backdating mentioned. That is, how much in the past must one go? It also alludes to rectification of defaults made specifically under provisions of the Act, right? Which is either under sections 4, 3, and 6. If you've not taken the permission or approval, now's the time. Here's the opportunity for you to come before the NBA and seek approval. But it does not delve into situations where the research was conducted before the BDA came into effect. That is, retrospective effect of the legislation was left moot or seemed to have left moot. A third observation is that patents can be granted regardless of whether permission for a biological resource is received. This is because breach of a provision on access to a biological material and research has no bearing to the criteria for granting patents, right? You're getting a patent granted because your patent contains an invention that has an inventive step, is not obvious, and is not something that had been anticipated to a person skilled in the art. Of course, there is an industrial application involved, but this criteria has been explicitly mentioned in the Patents Act 1970. And if you're looking internationally, we've got the TRIPS agreement for this. Nowhere does ABS form a criteria for granting patents. Now, there are penalties, of course, for breaching the ABS regime provided under Section 55 of the BDA, where a person could be imprisoned for up to 5 years or with a fine extending to 10 lakh rupees. But these penalties are pursued by the NBA separate from the patent grant process. The fourth observation is the seeming extraterritorial jurisdiction of the NBA under Section 6. Now, in case an inventor seeks to file a patent application based on an Indian biological resource outside India, approval from the NBA is required. That's what Section 6 seems to be saying. Now, does this mean the right to file a patent application, say by an Australian inventor, before the UK Patent Office on an invention based on a tiny amount of neem oil from India is prohibited due to Section 6 without approval from the NBA? Can Indian law govern the patent prosecution process in the UK by making grant of IP rights subject to the Indian ABS regime, where hypothetically the local law may not provide for such an overlap? A concern quite evident from Section 6 is that merely filing a patent application without approval from the NBA means the Australian inventor is in violation of the Indian law, and the Australian inventor may not even be aware of such a law. The fifth observation is that the Indian Patent Office in January and March of 2016 through orders 1079 KOL 2009 and 852 KOL 2010 has rejected patent applications for sourcing biological material from overseas while the same was available in India. Why did you go overseas when you could have resourced the material from India? As a consequence, the controller was of the opinion that the patents ought not to be granted because it was in violation to sections 33A and section 33G of the Indian Patents Act 1970. That patents are to be granted to make an invention available to the public at a reasonable price. But if you're sourcing your material from overseas, automatically the cost will go up. So the controller further directed the applicants to seek approval from the NBA for that Indian biological material to be sourced. And the question is, has India made the cost of sourcing biological material and approval from NBA a criteria for granting patents in lieu of Section 83? Now, internationally, the patent regime is considered separate from the ABS regime. If you're talking about the international sphere, the concern today is not to make the parameters of ABS a condition of the patent regime. Rather, the concern is to track misappropriation of biological resources forming a part of the patent application. That is, what if a person uses an Indian biological resource without approval and is granted a patent? How does the NBA track such applications? The task is made harder because the patent and ABS processes are different and we have different authorities monitoring them. ABS is monitored by the NBA internationally and or authorities similar to the NBA in different jurisdictions, and the patent grant process by the Indian Patent Office or the IPO. Now, it is moot whether the NBA has complete access to the IPO's database and patent prosecution information, assuming the NBA has access to the IPO's database. Does the NBA have access to databases of other countries to check whether an Indian biological resource forms a part of a patent application? And how has the prosecution really taken place? Interestingly, patent examiners in India check for whether approval for an Indian biological resource or its research has been received when they assess Form 1, that is, application for the grant of a patent, and within that Form 1 is Para 12, Subpart 3, where the applicant is required to disclose whether permission for the Indian biological resource has been received or not. Now, while there have been measures to manage the use of Indian biological resources in patents before the IPO, similar tracing mechanisms may not be available if the patent application is filed directly overseas. Now, the difficulty in tracing breaches of ABS has arisen due to the lack of a mandatory disclosure in patent applications filed globally. Some countries may not require disclosure in patent applications with respect to where is the biological resource being taken from, or whether the approval is there in the patent application process for accessing biological materials. It is limited to disclosure where the biological resources have been sourced from their own country, like what India has done. If you've sourced an Indian biological material, then you have to make that disclosure in the Indian patent application before the IPO. But let's say you've sourced your biological material, say from South Africa. You don't have to make that disclosure in the patent application per se. Now, if an Indian biological material forming the basis of a patent is directly filed before an overseas patent office, the non-compliance could be harder to trace. The difficulty in tracing biological material for the purpose of obtaining permission is an issue that has been observed internationally. As a consequence, the World Intellectual Property Organization, or WIPO as we call it, has issued a mandate. or has provided a mandate to the Intergovernmental Committee on Intellectual Property and Genetic Resources, Traditional Knowledge and Folklore. Yes, that's the name of the committee. It's fairly long. And so we just shorten it and call it the IGC. And what the IGC is supposed to be doing is to facilitate text-based negotiations on a legal instrument for the protection of genetic resources, traditional knowledge, and traditional cultural expressions. Now, the negotiations may culminate into a treaty. The text of the legal instrument was commissioned in 2004, and since the draft has developed, and negotiations, of course, are still ongoing. At the last meeting of the IGC on the protection of genetic resources was in March 2018. This was called the 35th session of the IGC, where the current working draft of this legal instrument entitled the Consolidated Document Relating to Intellectual Property and Genetic Resources, Rev 2, that's short for Revision 2, was discussed. Now, initially, the plan was to have one single document for the protection of traditional knowledge, traditional cultural expressions, and genetic resources. However, as negotiations progressed, the draft was eventually divided into three working drafts, each one on a specific issue and carrying focused provisions. So we have three working drafts at the moment on traditional knowledge, another one on traditional cultural expressions, and a third one on genetic resources. And what happens is that the IGC has meetings specifically on each one of these working drafts. So in the working draft on the protection of genetic resources, a key provision is Article 4 on the disclosure requirement that could potentially make it obligatory for a patent applicant to disclose the country of origin of the genetic resource or associated traditional knowledge. And in case the origin is unknown, a declaration to that effect. Now, this could be a higher threshold of disclosure than simply disclosing the place of occurrence under Section 3 of the BDA, because today permission is required simply if the resource occurs in India. Now, the word occurrence here insinuates an ex situ source that may not have historical origins in India, but may simply be grown in botanical gardens or cultured in DNA banks, attracting permission from the BDA. It may also cover digital sequence information on genetic resources, although this has not been explicitly stated in the BDA and is a matter of interpretation. Now, here's the tricky part. The tricky part is that under Section 10, subsection 4 of the Patents Act 1970, the patent application is required to disclose both the source and country of origin of the biological material if not publicly available. So here's the catch. If it's not publicly available, then you make the source and the country of origin. You disclose it in the patent application. So in case the disclosure is incorrect, it forms a ground of patent opposition. Now, the term source and country of origin have a different meaning. Source could simply mean the organization or person the material was obtained from, like your university. The country of origin is the place where the biological resource was observed and raises issues like nativity of the resource, a fairly contentious issue there. At present, Section 10, subsection 4 on disclosure is seldom used since the source and country of origin of popular biological material is publicly available. However, there could be a possibility for the international instrument to make disclosure on the country of origin a mandate. And the issue could become complex where resources like, say, Cocos nucifera or the coconut tree that could have a potential range of historical origins spanning different countries like India, Sri Lanka, Malaysia, or Indonesia, to name a few, are the countries of historical origin. So the question that may arise is which country should approval be taken from? Now, given this background in mind, I hand it over to our keynote speaker to take the discussion forward.
Thank you, Divyangana. I think you've pretty much covered half my presentation, making life a little easier for me. But having said that, thank you for organizing this webinar. Thank you both to Jindal Global Law School and Actus Legal, especially Rajneesh. for thinking that I could do justice to this topic. Thank you for having me. And good morning to everyone. Thank you for joining me on a Saturday morning. And as Divyangana has already set the context of this discussion as to the intersection between Biological Diversity Act and the Patents Act, uh, my aim in the next 20 minutes is to do the following. And I hope I can stick to the time limit so that we have maximum time for question and answers, which is to give you an overview of the regulatory regime under this act, to touch upon some concepts and provisions, during the course of which I will attempt to answer some of the questions that Divyangana has raised, and finally look at how this act intersects with the Patents Act, where we look at Section 10, where we look at Section 6 of the Biological Diversity Act, Section 10 of the Patents Act, and see how they intersect. And finally, look at what is the way forward for this intersection. How is it going to play out, especially in the light of what is happening with the WIPO Intergovernmental Committee and this international legal instrument that is proposed on specifically on the issue of IP and genetic resources. So I just have a short presentation that I'd like to share, which, just give me a moment. I hope you can all see my screen. Divyangana, if you can just let me know that if you're able to see my screen.
Yes, yes, we're able to view the screen. Yes.
Yeah. So as I said, this is going to be the scheme of my presentation, and hopefully not delve into too many specifics as to the provisions and the interpretations. I think we still need a lot of litigation under this act. This act is, although over 20 years now, almost close to 20 years, but we still haven't seen the kind of litigation that have interpreted many of the provisions, as Divyangana also highlighted. So my attempt is just to set the context for the specific issue that we're discussing on the intersection between Patents Act and the Biological Diversity Act. Now, just to give you a bit of introduction, it's no wonder that India is one of the first countries to come up with this Biological Diversity Act, given our rich biodiversity, the 4 biodiversity hotspots, which are globally recognized, our immense contribution to crop biodiversity. So it's really no surprise that our country came out with this legislation early on to conserve and protect biodiversity. Now, as Divyangana pointed out, India is a party to the Rio Convention on Biodiversity. We're also a party to the Nagoya Protocol. So this legislation basically adopts the objectives of these international conventions and implements them with a regulatory scheme by setting up authorities, which is the National Biodiversity Authority at the national level. And at the state level, we have the State Biodiversity Board. And at the grassroots level, the local level, we have what is called as the Biodiversity Management Committees. So the essence of the legislation is conservation of biodiversity, sustainable use of the bioresources, equitable and fair and equitable benefit sharing of that stems from the use of the biological resources, and implementing a regulatory regime that achieves these objectives. Now, 2 points to be noted here is that the scope of this act is not just to biological resources, but also to associated traditional knowledge. Now, of course, the term biological resources is defined under the Act. We'll come to that. We'll come to the exceptions under the Act, what is covered, what is not covered. But with respect to the term associated traditional knowledge, there is no definition. So, in common parlance, first principles understanding, it is the knowledge that is based on these bioresources that have been developed by humans over the years, centuries, and passed on from generation to generation, documented, undocumented, it includes it all. The second most important thing is to understand the scheme of regulation under this act. Now, the scheme of regulation under this act, it connotes a prior approval. Now, an approval that you need to take if you're covered within the act and for doing the activities that this act regulates, you need to take it before you undertake any of that. Therefore, to give you an example, before I access any bioresource or the knowledge associated thereto, before I undertake any activity, this act requires me to take a prior approval. Now, whether I'm required to take a prior approval, what kind of approval I am to take, at what time I am to take, and what are the obligations that follow once I get this approval is what the act delineates. Now, in order to do so, in my view, the Act does this on two platforms. The first platform, as Divyangana explained very well, is the platform where you determine who is the person. So it determines the category of persons. So quite simply put, I'm not going to go into details. I'm just going to say the two category of persons are foreign person and Indian person. Now, we already discussed that the foreign person here involves a person who's not a citizen of India, is a non-resident, is a body corporate not registered, if registered, has any non-Indian share capital participation or management participation. So that is one kind of category. The second category are those that do not fall under this category. So let's, for our reference purpose, call it wholly Indian. Now, depending on which of these persons do what kind of activities, the Act comes into play, and it determines the kind of approvals that you need to take, the stages of approvals that you need to take, which are all prior approval in all cases. And once the approval is obtained, what kind of obligations. Now, these obligations are what Divyangana was referring to as access and benefit sharing. Now, it's not that all kind of activities have access benefit sharing obligations. Now, if I'm only doing research, there is no concept of benefit sharing because there are no, a research may not culminate into some benefit. I may just do the research, I may hit a dead end. So there are no access benefit sharings contemplated vis-a-vis research. However, if I come up with a commercial product, if I come up with a patent, if I come up with some final product that can lead to commercialization, then there are benefits that can be arisen, and therefore those benefits need to be shared. Now, you may ask, where are these benefits being shared with? Who is it? I'm sorry. Yeah, thank you. So it needs to be determined that these benefit sharing that is to be done, how is it going to be done? Is it that, it goes into some random fund and we don't know what happens? No, the Act even goes into that level of, details as to what happens to that benefit sharing, whether it's monetary or non-monetary. Now, it need not be monetary in all cases. It can be non-monetary benefit sharing. So how is that implemented is all that this Act looks at. Now, coming to the activities, which is the second platform that I mentioned. Now, the activities, as you can see listed here, are number one, research, number two, biosurvey and bioutilization, number three, commercial utilization, transfer of results of research, obtaining IPR, and transfer of the accessed bioresource. Now, when I say resource, please keep in mind that I'm also talking about the associated knowledge with it, the traditional knowledge. Now, see, these are the activities that this Act governs. So here lies the differences in the persons that we had previously looked at. For instance, now a research approval is only needed for a foreign person. It's not needed for an Indian. So here, sitting here, if I pick up the neem leaf outside my window and I do a research, I'm a wholly Indian person, I don't have to take any approval. But if I'm a company, I'm a multinational company, I have foreign shareholding, I want to do research on neem leaves, I need to take the prior approval of NBA. Now, when it comes to something like commercial utilization, whether an Indian does it or whether a foreign person does it, you need to take approval. Again, there the difference would be which authority you go to. So a foreign person always goes to the central authority, which is the National Biodiversity Authority, whereas an Indian person can approach the respective state biodiversity authority. Here we see a delegation of powers between the central and the state boards. Now, questions of transfer of results of research. Now, here this is interesting. This is not your when you're transferring results of research. So, say for instance, I do some research on the neem leaf. I've come up with something, and I want to transfer this to a foreign entity. So here, the important under Section 4 we look at is that when you're transferring to a foreign entity, I need to go take an approval. So I may not take an approval for doing the research, but when I transfer it to a foreign entity, I need to take an approval. Then coming down to the last category, transferring of already accessed biological resource. So here when I say already accessed is that you already have the approval for doing the research, the category 1 here, that is a foreign person. You've done the research, now you want to transfer it to your holding company abroad or another company, you want to collaborate with another company, another research organization abroad, you still have to take approval. So what we see in these regulated activities is a holistic enforcement activity. The NBA basically, in my view, wants to know everything. They want to know who touches the biological resource, what is done with that, what research results are being sent, is that resource being sent? It's a holistic supervision, in my view. That is what this Act aims at. So before we go further, just a quick look at some of the definitions because Divyangana alluded to this. Let's look at the definition of biological resource here. Now it means plants, animals, microorganisms, byproducts, excluding value added product with actual or potential user value, but does not include human genetic material. Now, Divyangana mentioned curiously, why is human genetic material excluded? Now, the reason for that is if you see the basis of the UN Convention on Biodiversity, the Nagoya Protocol, this act, we saw the objectives. The underlying principle is the principle of recognizing sovereign rights over a country's bioresources. That is, our country's bioresources are our sovereign rights. No one else can exert rights on them. Now, we can't possibly have that kind of sovereign rights over humans. Now, humans don't belong to anyone. Humans are individual beings. They belong to themselves. They don't belong. I mean, we associate, we are citizens of a country, but we're not sovereign rights of a particular country. So that is the main reason, right from the initial round of discussions of the UN Convention, human genetic material or any material related to human genome was excluded from the purview of the act, because you can't impose that kind of sovereign rights over humans. Now, as we mentioned, the activities of biosurvey, bioutilization, coming down to commercial utilization research. Now, here I'd like to point out one thing on commercial utilization is that it does not include conventional breeding. Now, this is a major focus from a practical perspective, just to give you a practical perspective of someone who deals with clients in these matters, is that these words need to be defined, because a conventional breeding, the perspective of a breeder who's doing conventional breeding vis-a-vis a perspective of a lawyer, vis-a-vis a perspective of a student of science would be completely different. So therefore, while this act has done a good job in defining most of the terms, some of the key terms, especially the exception terms, have not been as well defined. So now the job lies with the courts, the job lies with litigants to take up matters and get these terms defined in a more exhaustive manner, so that there is clear understanding as to what is included within the scope of the act and what is excluded. Now, you'll also notice one pertinent thing is that these terms that we've looked at, research, biosurvey, bioutilization, commercial utilization, may not be mutually exclusive. Something which comes under the ambit of research could also come under the ambit of biosurvey, bioutilization. Something which is excluded under the purview of commercial utilization, like conventional breeding, one may argue, I mean, any lawyer would argue that it could be research. So these are the things that you need to keep in mind, that these are not mutually exclusive terms. They are categories to ensure proper implementation of the act. They have different forms and different ways the approvals are given. So these are just to facilitate that, and they're not, crystal clear. They don't act in silos, so to speak. Now, coming to value added products. Now, to the best of my knowledge, no court has interpreted what this term really means, value added products. Now, there is a definition which says means product which may contain portions or extracts of plants and animals in unrecognizable and physically inseparable form. Now, if I were to give you an example, that would be a popular example that is cited in our legal circle practicing biodiversity law is Chavanprash. Now, Chavanprash, if that was my starting material, I could argue that I don't fall within the purview of the act, because that's value-added product and that is excluded under the definition of bioresource. Why is Chavanprash a value-added product? Because it may contain portions or extracts of plants. So it may contain all your different herbs and plants and other materials, minerals, sona, chandi, as we know, and metals and all of that. But it is in an unrecognizable and physically inseparable form. No one can possibly separate the different constituents of the plants and the metals and all of that goes into the Chavanprash. So that is one example. But again, we need more practical examples. We need to understand some complicated questions as to whether oils will be value added product, oils, because they undergo some sort of process. Somebody making neem oil is just not taking an extract by crushing the leaf and taking the oil. There is some sort of chemical processes going on, may not be as complicated, may be complicated. So we don't know. So those are the kind of gray area issues that still need to be addressed under this act. Now, yes, coming to the relevant provisions quickly, we'll go through these. Section 3, as I said, Section 3 says no person referred to in Section 3.2, which is the foreign person, can, without the approval of the NBA, the prior approval of the NBA, obtain any biological resource occurring in India. I stop here when I want to discuss the term occurring in India. Now, Divyangana alluded to it. Does it mean it has to be historically originated in India, or does it have to be, occurring in an ex situ condition? Now, the word occurring is broad, so it covers ex situ conditions clearly. So, for instance, potato or chili is not native to India. We got it from different countries, Brazil, Chile, wherever. But these are not but these are still occurring in India. They are grown in India. They're now part of the biodiversity of our country. You know, potatoes are grown widely here. Chili is grown widely here. Eucalyptus, for instance, comes from Australia, originates in Australia, but freely available here. And we have eucalyptus plants growing in the wild, in fact. So therefore, the act today, the way it stands, is that if you're touching any bioresource which is occurring in India occurring on Indian soil, whether it is wild, whether it is cultivated in a university, in your back garden, wherever it is, if you're a person who needs an approval and you're accessing it, you have to get an approval. So that is, and importantly, the approval is for what? If you're doing any one of these three activities, which is if you're doing research, if you're doing commercial utilization, if you're doing biosurvey and bioutilization. So if I'm just accessing those bioresources, if I'm plucking flowers to offer it to a god, no, that's not covered under this act, because that's not an activity covered under this act. It's only these activities, and if it's occurring in India. So to answer Divyangana's question, if someone were to access something sitting in Australia through an Indian bioresource from India, he gets it through someone, he needs to take an approval. Whether it's a minute quantity of his invention, whether it's a minute part of his research, that is not covered. The quantum is not determined under the Act. You touch and you take approval. That is what the Act says. Here, we've already seen Section 4. I don't want to delve more on Section 4. It talks about transfer of results of any research to a foreign person. Let's jump straight to the provision where we're really in contention today, which is the Section 6, which talks about patent rights. In fact, pertinently talks about any intellectual property right, but then it follows it up with the word invention. Now, invention is generally used in the context of patents. So therefore, if your patent application is based on a research or information on a bioresource obtained from India, you cannot get that patent application granted without the approval of the NBA. Now, although in this case, it is a case where you have to get a prior approval, but there is a proviso which says that you can get it even just before the grant. So you might have filed the patent application, but you can still get it before the grant. You can take the approval after filing the patent application, bit of leeway for convenience sake that is given. Now, the question that Divyangana posed in this scenario was that I have 40 resources of bioresource, and it's just that one resource that I have taken, an Australian inventor. I'm an Australian inventor, and I take it just that one bioresource from India. Am I supposed to go to the NBA? The answer is yes, in fact, an emphatic one at that, because the wordings of the statute are invention based on any research or information. In fact, before he even files the patent application, the fact that he has touched that bioresource, even though it is just a minuscule part of his final product, even the fact that he's touched the bioresource, he should have taken an approval under Section 3 for research. And then comes the question of Section 6 when he files a patent application. So the chain of control under this act is from the time you access it, why do you access it? Then if you commercialize it, you have to take an approval and pay benefit sharing on that commercial utilization. If you file a patent application, you have to take the prior approval before before grant of the patent application. And then when you license it, or when you assign the patent application, whatever royalties you get, you have to pay a share of that based on the regulations under this act to the National Biodiversity Authority. So like I said, it is a holistic control. They want to know everything at every stage as to what the bioresource has undergone. This Section 7 is what I mentioned, that there is a difference in regulation vis-a-vis an Indian person and a foreign person. So an Indian person doesn't need to go to the National Biodiversity Authority for research approval, but definitely needs to go to the State Biodiversity Authority if they're doing biosurvey, bioutilization, or commercial utilization in a commercial utilization sense. So only if an Indian person is doing some commercial activity, whether it's biosurvey or direct commercial utilization, an intimation, the word here is not prior approval, but an intimation needs to be given to the State Biodiversity Authority. And there are issues on whether ABS applies to an Indian person. There is an ongoing litigation, in fact, a litigation that my firm is part of. So I won't say much because it's a pending list. I will say, but there is a contentious issue as to whether wholly Indian entities need to pay access and benefit sharing under the Act. Finally, Section 20, not that important, so I'll just quickly skip. It is for those who have already obtained the approval for access of biological resources. When they transfer the bioresource itself per se, then a separate approval is contemplated under the Act. Again, a prior approval. Just to give you, it's although it seems like an all encompassing act, I've used the word whole and holistic, and it seems to cover the entire planet, but there are certain exemptions. Again, a very contentious exemption, this one, which says that the government, by notification in consultation with the NBA, can declare any provisions of the act to not apply, including biological resources normally traded as commodities. Now, the way we've discussed the act, a person who is accessing potato to make potato chips could also be covered under the scope of the act. Therefore, the government thought it best to exclude people who are only trading with the biological resources. They're only trading them as normally traded commodities. So they've been excluded. There's a list of about 421 plant species. Uh, Interestingly, this is a dynamic list. They're looking at whether to include milk, whether to include eggs, because they're not typically plant, they're different sources, animal sources. So there is discussion whether to increase the quantum of the list. But as it stands today, the 421 plant species, if anyone is merely trading them as commodities, then they're exempt from the act. Uh, Pertinently, I would like to let you know that there is a pending litigation before this Honorable Supreme Court on the vires of Section 40. There is a challenge against the very vires of Section 40, so that is pending. We're going to see a lot of litigation on this provision in the future. Uh, Divyangana has already alluded to this. I think this is the provision which leads clients to us, because there are penal consequences if you do not if you do not comply with the obligations under this act, extending up to imprisonment and a fine up to 10 lakhs. So a very important act that companies and persons need to keep in mind, and they need to be in compliance. So let's come to the Patents Act. Now, we've seen that in order to get a patent application on research or information based on bioresource, you need to get the prior approval of the NBA. Now, forgetting the BDA Act for a moment, let's look at the Patents Act. Now, the Patents Act says under Section 10, which is what we popularly call as a provision of sufficiency, which determines what is the sufficiency requirement of a complete specification. Now, when you file a patent, you file a complete specification, which is the description of your invention and a list of claims. The claims are what you claim your monopoly on. Now, how sufficiently should that complete specification be described? Now, in that regard, Section 10(4) says that the requirement to disclose the source and geographical origin of any biological material mentioned in the specification. So it need not be that the biological material forms the crux of my invention. If it is mentioned in my specification, then I need to disclose it only when I satisfy these two conditions, which is if it is not described in the complete specification, such as to satisfy clauses A and B of 10(4). A and B of 10(4), don't have to worry. It's just that the invention has to be fully and particularly defined. The best method of working the invention has to be described. So if the biological material mentioned does not satisfy A and B of 10(4), and if it is not available to the public, a cumulative condition. So only if these two conditions are satisfied, then I am required to disclose the source and geographical origin of my biological material. So here we see that the Patents Act sort of pulls back. It's not as giving as the BDA. It's not saying that go ahead, mandatory disclosure. If you're touching a bioresource in your invention, disclose it. So here we see a bit of an intersection is clearly there, but the intersection where the Patents Act holds back. So, but what I'd like to tell you in practice is that this is not how strictly the Patent Office is enforcing this provision. The Patent Office is not looking at whether you're satisfying these two conditions and then you have to determine. The moment they see in the complete specification there is a biological material, you mention a source, say I mention a malarial parasite, Plasmodium vivax, I mentioned that. The moment it's mentioned, the Patent Office is going to scan through your complete specification and ask you, where did you get this biological material from? Disclose the source and geographical origin. So they are in fact acting as an extended arm of the National Biodiversity Authority, and they are being proactive. They're not sticking to the letter of the law, and they're looking at the larger spirit. They're looking at the spirit of what these two acts, when come together, aim to do, which is to understand, to have full disclosure if any Indian bioresource is being made a part of a patent application. So this is how practically the Indian Patent Office is working in unison with the NBA. And the moment they see that a biological resource is used, they ask you to disclose its source. And if its source is India, they're sending you to the National Biodiversity Authority for an approval. Now, Divyangana raised an interesting question. If I file a patent application in America, and there are no disclosures, there are no requirements to disclose anything. America probably doesn't, to the best of my knowledge, they don't even have a biodiversity legislation. So how does it work there? Now, the point here becomes that once these applications, most of the patent applications are filed to the PCT route, and they are published widely. So if anywhere NBA is developing schemes to scan through these patent applications, they are developing databases, they are developing mining tools where they're scanning through different documents which are published on different databases. If they see the word India mentioned anywhere, they are sending notices. They are sending notices. So they are doing that in a way right now when there is no mandatory disclosure requirement everywhere in the world. The NBA is taking proactive steps in doing it. In fact, pertinently, I can recollect one case where NBA even sent a notice where they used digital sequence information of a parasite that was obtained from India. So here we're also looking at the term biological resources that we saw all encompassing seems to be including even digital sequence information. Whether or not that should be included or not is up for debate. But at least according to the NBA, they want to include that as well. So the intersection right now, if you see the letter of the law, seems to be that the Patents Act holds back. The Patents Act doesn't want a mandatory disclosure of source and geographical origin, but in practice, that is what is happening. The moment you disclose a biological material, however insignificant it may be, you have to disclose its source. And if its source is India, you are being sent back to the NBA to get an approval. Now, I'll just quickly come to the scope of, I think I've overshot my time by quite a lot, but quickly come to this scope of the negotiations that's going on at the WIPO. Now, here, you can all see the slides, but what I'd like to say is at the WIPO, these discussions are going on for almost a decade. And it's essentially a war between developed nations and developing nations. Developing nations, as you all know, are the ones that are holding the genetic resources, are the ones that are biodiversity rich. The developed nations, your United States, your Japan, your Europe, they are the ones who are opposing the mandatory disclosure requirement. They don't want that because they're the ones that are filing those patent applications. They're the ones that are actually commercializing most of the products that come out of these bioresources. So it's essentially a difference in a developing versus developed nation. And the discussions there are not just on whether there should be a mandatory disclosure or not, but also whether the scope, like Divyangana mentioned, should it be that even if I take a minuscule part, should I disclose it, or only if the biomaterial forms a substantive part of my invention, only then should I disclose it. So there are differences of opinion, and there seems to be no consensus till date. In fact, the latest that I know is that in 2020, the WIPO chairperson has circulated a separate draft, which seems to be tilting more towards the developed countries' interpretation of having a disclosure requirement only if the biological resource is material to the invention. The second part of the debate is also whether it should be restricted only to patents and plant varieties, or should it be open to all kinds of IP, for instance, copyright, where you would have the folklore and the traditional cultural expressions and those kind of issues involved there. So and another, like on the last bullet that is mentioned on my slide, is the definition of the term genetic resources. There's a lot of debate on that as well. Should genetic resources be restrained to genetic material, which have functional units of hereditary or genes, or should it be even for derivatives? Now, if you look at the Nagoya Protocol and the Convention on Biodiversity, it seems to include derivatives as well. So can this legal instrument be separate, or does it have to be in consonance? I mean, my view would be it has to be in consonance for it to have meaning. So, again, coming from a developing country, my view would be for it to be a mandatory requirement, irrespective of whether it is a substantial part or not. So these are the issues that the WIPO committee is grappling with, and hopefully we'll have some resolution in the near future. So with that, I'd like to conclude and over to Divyangana for questions.
Informative presentation. The content was explained so well that it was easy to understand. It was an enjoyable presentation, and I now open the forum for questions. So if anybody has got any questions, they can either type it out in the chat box or they can simply unmute and ask the question. Any questions? All right, I have one question. Can biofuels be covered under the definition of biological resources, or are these value added products? In the sense, what plant byproducts are biological resources and what are excluded?
Uh, Firstly, to answer your second question first, what are byproducts? Again, something which is not as litigated under the Act. The provisions have not been litigated, but there was one litigation which everyone here would like to read is an order by the NGT Central Zone where they determine whether coal is a bioresource. So what had happened was the Madhya Pradesh State Biodiversity Board was sending notices to coal mining companies, Western coal fields, all your public sector undertakings to say that coal is a bioresource and you need to take approval and you need to pay benefit sharing. Now, they're not entirely wrong. Coal is not outside the realm of bioresource in a large context of the term bioresource. It is formed by fossils of plants and animals. But the court determined that it doesn't fall within the purview of the definition under the Act. That is, it's not a plant, it's not a part, and it's not a byproduct. Now, in doing so, the court interpreted that byproducts, they went to, of course, the dictionary meaning of the word. Byproduct is a product which is incidentally created when you're aiming to create a primary product. For instance, my primary product is beer, and so when I'm fermenting, I get molasses, right? So that molasses becomes a byproduct. So in the context of plants, the court makes an observation. Now, this is obiter, this is not the ratio, but the court says byproducts will be honey, resins, gums, these are the kind of byproducts. But when you apply the definition, whether these satisfy those definitions, up for debate. But yeah, so coming to your question on biofuels, now biofuels are accessed from plants. So those companies will be touching plants. They'll be touching some kind of specific plants or herbs. Now, when they're accessing that, definitely they will fall within the purview of the Act. And to the best of my knowledge, biofuels are also regulated by separate government policies on biofuels. So they will have to comply with that as well. But yes, the fact that the starting point that they will access is a plant, they will fall within the purview of this Act.
And how does the NBA investigate cases of non-compliance? And can we actually classify them as misappropriation? Because there's a bit of a debate on how to, in fact, define misappropriation.
Well, till date, the kind of non-compliance enforcement that has been done, if you see, has not been done solely under the Biological Diversity Act. It's been done in conjunction with the Wildlife Protection Act. So, there were cases of some Czech scientists picking up insects in West Bengal. There was a case of a couple of Japanese scientists picking up some herbs in Western Ghats. These are the kind of non-compliance cases that we've seen, or, smuggling of sandalwood. These kind of cases, they invoke the Biodiversity Act, but not in isolation along with Wildlife Protection Act and other forest acts. So all of that. But the kind of non-compliance enforcement with these kind of provisions that we saw with penal consequences has not been done so rampantly that any small any small non-compliance has been met with a criminal action. No, that's not been the case. These have been actual cases of misappropriation, like you said. Like, these are the kind of criminal enforcement that we've seen under the Act. We are yet to see enforcement against big companies, MNCs. I'm sure there are entities that are engaged in some kind of biopiracy, but that kind of enforcement we have not seen. So yes, misappropriation is when they're actively smuggling things, when they're actively taking things outside the Indian territory without permission. So they've not even taken permission from the forest authorities. Those are the kind of cases that we've seen where the Biodiversity Act was invoked. Yeah.
And should the international instrument for the protection of genetic resources require applicants to disclose the country of origin, or is just the ex situ source sufficient? Because country of origin has it is a fairly high threshold to meet.
Absolutely. I mean, today, a common person wouldn't know where that origin is from. Like I said, I mean, we don't know, most of us don't know that potato is not originated in India. We think, aloo is like, staple diet, it's ours. But that's not the case. But having said that, the international legal instrument doesn't, at least the text that I've seen and the text that was recently circulated by the WIPO chair, they seem to keep it very open ended. They want to keep source as the source. If you're aware of the country of origin, please disclose it, but they don't hold you to it. you can disclose, you still have to disclose the source where you procured it from, which could be an XC2 source, which could be the source of country of origin. So it gives you an option. At least the drafts that have been circulated for comments till now seem to give that leeway. They don't insist on you determining the country of origin for obvious convenience sake, because not everyone would know the country of origin. And like you said, coconut, I mean, I for one don't know if the country of origin is India, but it's clearly available in many Southeast Asian countries. So definitely I have to inform, the legal text says that I have to inform the source, but if I'm aware of the country of origin, inform that as well. So that gives me an option.
We'll just take one last question and then we'll close the session. I'm mindful of the time. We've got Sabia here who's asking a question on what is the procedure to file a patent.
Okay. That the procedure to file a patent application is under the Patents Act. You have to first come up with an invention. You need to, before you file a patent application, you need to keep certain things in mind. Have you come up with an invention? Is that invention patentable under the Act? So there are certain exclusions under the Patents Act where you can't patent certain things. For instance, I can't patent something which is traditional knowledge. I can't patent something which is contrary to public order. I can't patent something which is a business method. So you need to first understand that what you have ready is an invention which is novel, which has inventive step, and which is industrially applicable. Most important is you need to see that your patent is liable to be patented, and then you go to the process of application, which is you file a formal application. There are different forms, there are different procedures, and you file that with the patent application. You can use a patent agent, a firm, law firm like mine. You can approach us and we can help you with that. But yeah, that's how you go about filing a patent application. And then it goes through the process of examination. It's a quasi judicial authority. So there is a process of hearing, and then your patent is granted. So it's a long haul, road to cover. So yeah, I hope that answers your question. Yeah.
Yeah, definitely it does. And all right then. So we'll probably end the session here. Thank you so much, Vindhya, for joining us today and for giving us your time. On behalf of both Jindal Global and Actis Legal, thank you so much. And we'll close the session now.
Thank you. Thank you for having me, and thank you for joining me on this webinar. Thank you, Rajneesh, once again. Thank you, Divyangana, for doing this together. Yeah.